Hello and welcome to Questions for Lawyers. I'm your host, Jeff Adelman. This is our second to last show for the season. For those of you who have been tuning in all year, I really appreciate your loyalty to watching the program. What we've tried to do here is bring guests on the show of different areas of law, try to explain that all of us don't do the same areas, even though by the Florida bar standards, we could do any area of law practically. It's not a good idea, and I think that has been on full display this season. But today, I'm really thrilled to have with me somebody who does constitutional law. He is the managing attorney for the Florida office of the Institute for Justice, and it is my great honor to welcome Justin Pearson to the show.
Thanks, Jeff. I'm happy to be here.
Justin, I remember meeting you, I want to say 6 or 7 years ago, and you were doing commercial litigation. And we talked on the phone, and you said, I'm so excited. I'm going to be doing constitutional law. Right. I'm going to be working for this nonpartisan group. I'm going to be working for the Institute for Justice. And I said, the Institute for who? And, well, 5 years later, you're still there.
Actually, 7 years.
Oh, it's been 7 years.
Flies by, yeah.
Can you tell everybody a little bit about the Institute for Justice?
Yeah, so the Institute for Justice is a national public interest law firm. What that means is I don't sue for money, and I don't charge my clients anything. We have over 8,000 donors around the country who pay my salary and all of our legal costs that go into our litigation. And for me, what that means is I spend my time going around the nation providing pro bono representation to small business owners, asking judges to throw out unconstitutional laws so that they can either, start their business or expand their business or say, what they want to say on their product labels, or in the case of civil forfeiture, keep their property that they should be allowed to keep. But I get to spend all of my time providing free litigation expertise to small business owners.
Justin, this is kind of like a dream for law students to be able to actually talk about constitutional law practice in that area. Can you tell everybody a little bit about what led you to the Institute for Justice?
Sure. Yeah. I got really lucky. I thought I was going to have my law practice for my career. That was the whole reason I went to law school. My mom was a small business owner here in Coral Springs. I went to law school because I wanted to have my own law practice representing small business owners like my mom. And I did that. I worked for a firm for a few years to get experience. I started my practice around year 4. And then, my mom was my first client, and I thought I was going to spend my career doing that, and very happily so. But I started noticing something that troubled me, which is that I was getting the same calls over and over again from different clients, and I wasn't in a position to actually fix the underlying problem. And my clients couldn't afford to pay me to file some big, expensive constitutional challenge. So I was just performing pain management. The phone would ring, it'd be the same call I had a million times before from another small business owner, where I was only providing, pain mitigation, basically.
Right.
And so I eventually got really angry. And so I started doing pro bono work, trying to take on some of these problems that I kept seeing, mostly involving food trucks and trying to get cities to allow food trucks to actually operate and compete. And as luck would have it, it was while I was doing that pro bono work on behalf of food trucks, just to kind of, make myself feel better about the legal profession. That's when IJ opened up their Miami office. And I'd been a fan of IJ's work for years. And so I called them up really just to tell them about these food truck issues and to see if they wanted to take them over. It led to a relationship where eventually a year later, I had the opportunity to close down my firm that I had spent so much time building and go work for this nonprofit group running their Miami office. It was, I couldn't pass it up. I mean, they now pay me to work full time doing the type of work that I happily did as pro bono work before, which I think is a great deal. My wife was a little surprised, but I think it's a great deal.
Absolutely. And it was a pretty big leap of faith on your part to do that.
And on my wife's part. My wife has an MBA in finance. And I'll always remember, we have 2 kids now. She was pregnant with our first at the time. And so, I explained to her, to my wonderful wife, that I wanted to close my practice and go, work for this public interest law firm. And this really well-respected national public interest law firm, but still, my wife, thinking as a finance person thinks, she goes, okay, Justin, let me get this straight. You want to close down the business that you've built for 7 years so that you can go make less money working for someone else, doing public interest law while I'm pregnant. I go, yes, that's exactly right. That's exactly what I want to do. You get it, And so she actually didn't say yes right away. But eventually, just because my wife is an amazing person who loves me a lot for some reason, she said, okay. And that was 7 years ago.
And you commute from, this area to Miami almost every day for this type of work.
I do. Now, thankfully, I work at a really cool place where they let me shift my hours to avoid rush hour, which helps a lot. And then, of course, I also do quite a bit of traveling around the country because I have cases all over the country. So I'm not always driving to Miami, but yeah, when I'm kind of driving to work on a typical day where I'm not on the road, it usually means commuting to Miami.
Well, I'm sure that there are quite a few small business owners that are watching this right now. And you said that a lot of your work involves small business owners.
Right.
But how does somebody go about hiring you? And what type of cases do you handle?
Right. And so I should point out what I'm really talking about now is the work I do. IJ also does other work in addition to my focus on small business owners. But whether it's the work I do or other IJ work, the best way to get in touch with us is on our website, ij.org.
Which we've displayed on the screen.
Right. There's a link on there that says, do you have a potential case for us? And you fill out the forms and you submit it. I will point out that, we don't have unlimited resources. We're a large firm. We have over 100 employees, 7 offices around the nation. But even with that being said, we can only take a relatively small percentage of the cases that are referred to us. So I don't want to give the false impression that if someone fills out that form, that means we're definitely going to take the case. But once you fill out the form, then there's at least a chance, like someone will review the form, that part we know for sure. And then it will be weighed against the other forms we've received to see which case would have the biggest impact on the precedent for everyone. We're really looking for people who aren't just trying to create a little carve out for themselves, but are trying to make things better for everyone, for all small business owners. And those are the cases we pick.
I'm sure that you see certain trends, and then those are the type of cases you kind of lean towards.
Yep, absolutely. Absolutely. That's true in all 3 areas, kind of all 3 topics that I work on for small business owners.
Right. And let's get into that because, we could talk about constitutional law from now until the rest of the year. It's fascinating.
And I'd be happy to.
Yeah, I would too. It's fascinating. One of the most fascinating areas there is in law. But your practice and what you do, you focus on 3 different areas. Can you talk about that?
Sure. So the first one, and really the place where I spend most of my time, is on the topic of economic liberty. And what that refers to is the right to earn an honest living without arbitrary restriction. So this doesn't mean the government providing you with a job. This doesn't mean you're guaranteed success. This means that if the government's going to get in your way when you're pursuing your job or your business, they have to have a good reason. Right? It has to be tied to health and safety. It can't be because some more powerful group said they don't want competition. And unfortunately, quite a few of our laws could be described that way, where a large incumbent convinces the government to create a barrier to competition that then prevents the small business owners I represent from being able to compete. And that's where we get upset and that's where we get involved.
This include like occupational licenses as well? Yeah,
really for me, it includes 3 things where I've spent quite a bit of time. Occupational licensing is one, food truck bans are another, which is, kind of works out since that's really what brought me to IJ.
Right.
And then certificate of need laws.
All right. Can you talk a little bit about the food truck cases that you handle? Because I've always been fascinated by that. And I see your work a lot of times gets press concerning the food trucks.
People love them, and they should. Food trucks are great. They're a wonderful stepping stone for people who want to open up a restaurant but don't have the capital yet. And oftentimes, once the food trucks become successful, the owners do open up restaurants. But even still, we see this phenomena that plays out in many cities. Not all. Some do things the right way. But in many cities, what will happen is local restaurant owners will get scared and they'll go to the city council and have them pass a law that either says food trucks aren't allowed at all, or if they are allowed, they have to stay a certain number of feet away, like 300 feet away or 500 feet away from any business that sells food, which usually takes care of all of the downtown area. And it's unfortunate. It's unfortunate for a couple reasons. Constitutionally, it's unfortunate because the city, in order to follow what's really a state constitutional issue at that point, the city has to tie in the regulation to what's called the police power, which is public health and safety. Banning competition to favor one competitor against another is not within the police power. It's not a constitutional use of power. And so that offends me as a constitutional lawyer, because it's the consumer's right to choose where they want to purchase their food. That's not the government's job to do for them. But even still, I think that the thing that's particularly disappointing to me about those bans is that the logic behind them isn't even accurate. We have seen over and over again that when you let food trucks into a city, they actually help out the local brick and mortar businesses, including the local restaurants. Because the way it plays out these days is that people follow those food trucks on social media and they will leave the location where they live to follow that food truck into a new location. And so then, you see these cities that spend all of this money trying to attract people to come check out their city, and food trucks will do it for them for free if they just don't ban them. But unfortunately, most restaurant owners and most city council members, they haven't read all these studies. They haven't seen all these examples where food trucks have helped out restaurants, and they have this knee-jerk reaction where they just ban them, and then that's where I come in.
Yeah, and to be honest, I've been seeing them a lot more at different events that you wouldn't expect to see them, and I think that is a result of the work that you and others have done through the Institute for Justice.
Yeah, thank you. I mean, obviously, we're not the only group that helps food trucks, but we really have led the way, both with our lawsuits, where we've litigated this issue more than anyone, and with the strategic research we perform. We have quite a few, PhD academic people who study the kind of scenarios that play out across the nation to see, well, what happens when food trucks are allowed? What happens when food trucks aren't allowed? And time again, they find out that food trucks actually help the local business owners. And so then, of course, that helps us, whether we're trying to convince a city to do the right thing, the easy way, or whether I have to go to court and ask a judge to rule their ban unconstitutional.
Now, another topic, we talked about economic liberty. Mm-hmm. Free speech comes into play with your work. Can you give us some examples of that?
Yeah, unfortunately, we see kind of the same dynamic of entrenched incumbents trying to prevent competition play out with free speech too, where large businesses and large trade associations will try to get terms defined in a certain way where it fits the way they want to do things, and it excludes kind of niche industries and people who want to be a little bit more creative. But business owners don't lose their First Amendment rights when they open a business. And so just to give one example, one of the cases that I'm probably best known for is a case I had here in Florida representing a small dairy creamery up in the Florida Panhandle. And what happened to them is they were an all-natural dairy creamery and still are. So they pasteurized their milk. That just means they heat it up. Mm-hmm. And then, after they heat it up, they refuse to add any other ingredients to it. So, they sell whole milk, they skim the cream off and sell the cream. The skim milk that's left over, they sell that too. But there are no additives added to any of these products. And so one day, the state of Florida Department of Agriculture goes to them and say, listen, we have a problem. You have to stop calling your skim milk skim milk. They say, well, wait a second. Our skim milk consists of one ingredient, and that ingredient is skim milk. And say, yes, that's the problem. The problem is Florida had copied an FDA regulation that defines the product skim milk as having 3 ingredients. The first ingredient is skim milk, which should tell you all you need to know right there.
You could stop right there.
You should be allowed to, right? The other ingredients are vitamin A and D additives, which are fat-soluble vitamins found in the cream. And so basically what the regulation said is when you skim the cream off, you have to artificially replace these 2 fat-soluble vitamins that, are obviously skimmed off with the cream. And this law was passed by a giant dairy trade association. They know that economies of scale benefit them. Their biggest fear in the world is that people will start viewing their local creameries the way people view their local craft breweries. Like, they do not want variety at all. They actually opposed my lawsuit when we went up to federal appellate court at the 11th Circuit. They filed an amicus brief asking the court to rule against my client, which I think it surprises some people, right? Because you'd think that this trade association that represents creameries would like want to come to the rescue of this little creamery. But instead, they were the biggest opposition. They were the ones who pushed for this ridiculous law and were willing to spend lots of money on high-priced lawyers to write amicus briefs to help defend that law. Thankfully, amicus briefs aren't usually read and don't usually have much of an impact, but still, they tried. And so, I went to court and I argued, listen, the government concedes that my client's skim milk consists of one ingredient, which is true. And they concede that one ingredient is skim milk, which is also true. And they concede that it's legal to sell and safe to treat and safe to drink, which are both true. They just say that it can't be called what it is unless you add other things to it. And we actually lost at the trial court because that type of argument had never won before with what are called food standards of identity. And so it kind of understandably scared the judge a little bit, or just, he wasn't willing to do what we were asking. So we went up to appellate court, and the federal panel ruled unanimously in my client's favor. And that was the first successful First Amendment challenge to a food standard of identity in U.S. history. The state of Florida did not seek cert from the U.S. Supreme Court, so that was the end of that. But now that precedent, and one thing that's really kind of satisfying to me is not only did that precedent help my client who's selling skim milk with a clear label again, but it's being used in all these other cases. So you see these situations now where like veggie burgers are being banned because the meat industry is pushing for them. Well, now the cases are being filed relying on that precedent I created at the 11th Circuit. We also see
that's a big deal, right?
It is. Yeah. We also see this issue that's starting to percolate now where the dairy industry is trying to get terms like coconut milk and almond milk banned because they don't come from cows. And so when the FDA starts enforcing that reg, which it's talking about doing, there'll be lawsuits, which again will rely on this precedent I created on behalf of this little dairy creamery in the Florida Panhandle. And so, the number one, I think, source of joy I get is seeing how I helped the small business, but then also seeing how that precedent plays out and is used going forward is satisfying also.
Out of curiosity, if they didn't want them to call it skim milk, did they say what they wanted to call the product that was just skim milk without additives in it?
They changed it a few times. At one point, it was imitation skim milk. At another point, they tried to, in their mind, be reasonable and come up with something that didn't call it imitation. So they came up with non-grade A milk product, natural milk vitamins.
Well, who wouldn't want to drink that?
No, exactly. And then when we were up on appeal, if you read the appellate decision in a case called Ocheezy Creamery versus Putnam, which is the case style, their position there was that it should be called imitation milk product. And the court just rejected that, 3-0, and said, no, it's skim milk. They can call it skim milk.
When they want to call it those things because nobody would want to drink that stuff.
That's exactly right.
Well, I want to get into the last area that you practice, which I know is near and dear to your heart, property rights.
Yeah, that's true.
And property rights, I think that, you've been very involved in that. And in fact, you've been involved in crafting some of the laws that we have currently today.
Yeah.
Can you talk a little bit about civil forfeiture and what that is?
I'd be happy to, although I might get angry. Because civil forfeiture should not exist. It's this tool that was supposed to be used in very rare situations involving tariffs and imports back in colonial times. And then because of the war on drugs, its use has just grown exponentially. And basically what it is if the police want to, if they find anything about your property to be suspicious in their mind, they can take the property and keep it for themselves, keep it for their agency. And then you have to sue to get your own property or money back, even though it will probably cost more to pay a lawyer to file a lawsuit than your property is worth. The average forfeiture is only for a little over $1,000. And of course, because the police get to keep the money and property for themselves, that creates a tremendously perverse incentive for them to find everything suspicious. And just so we're clear, they don't have to arrest anyone. They don't have to convict anyone. Our position is no one should lose their money or property without being convicted of a crime. But unfortunately, civil forfeiture turns that presumption of innocence on its head. This really first came to my attention when I joined IJ about 7 years ago. I had a case representing a small business owner in California who was the victim of civil forfeiture, and we won that case. And that led to a bunch of phone calls where people here in Florida, who saw the articles would call me up and say, Mr. Pearson, I've never been arrested in my life. Why did the police take my money? And why won't they give it back? And it was just heartbreaking. All right. These individuals will never trust our justice system again. They won't. And then what happens is they would go to the police and the police would say, yeah, well, maybe you are innocent. Maybe if you fight it out, you might get your property back, but that'll take 3 years and $20,000 in attorney's fees. And we only took, $800 from you. So why don't you let us keep part and you keep part and we both go our separate ways? It's just a shakedown. That's all it is a shakedown.
It's scary.
Yeah.
It's really scary.
Yeah. Yeah. If you're scared by it, then you understand. Mm-hmm. And so
there's no due process at all in that.
No, there really isn't. And so at best, there's the kind of due process you get in civil court because it's civil litigation, basically, where the government is seeking to obtain that money, from circuit civil court, not criminal court here in Florida. Although to be fair to Florida, this happens everywhere. But not the type of due process protections you get in criminal court. And so thankfully, over the last decade or so, there's been an increasing amount of awareness of this problem, in large part due to the organization where I work, IJ. And so I was able to rely on that, groundswell of awareness and go to Tallahassee, for a couple of years in a row. But then it culminated in 2016, where I led a coalition of disparate public interest groups. So I had my friends on the ACLU representing the left. I had my friends from like free market groups like the James Madison Institute representing the right. And I kind of have a foot in both camps. My conservative friends think I'm liberal and my liberal friends think I'm conservative. And so I was able to lead that coalition and help, with the help of some, motivated state legislators to get meaningful reform passed. Which was fantastic. So now in Florida, as of 2016, if there's a civil forfeiture, there are really three types of protections. There's due process, transparency, and then attacking the profit incentive. So regarding due process, now the burden on the government is beyond a reasonable doubt, the same as in criminal court, which is terrific. Additionally, there's finally reporting requirements so people can see what's going on. There was no transparency before 2016. And then the third thing that I think people don't always understand, but which I realize is the most important part of the reform, is that we attach the profit incentives. The cost to file a forfeiture for the government was raised to $1,000. And then on top of that, they have to pay an immediate $1,500 bond. So what we basically did is we took away the profit incentive for any forfeitures of less than $2,500, which is the vast majority of forfeitures. And so it really impacted these low-level shakedowns that were going on. And
using your example of $800, you can see how even in that case, it would have made a huge difference.
The government just wouldn't have done it. The police would not have gone after it. And we've actually seen stories in the last couple of years where police departments have said, well, it no longer makes sense for us to do civil forfeiture from a profit standpoint, so we're not going to do it, which shows you that they weren't really using it to fight crime, right? Most crime fighting does not lead to profit. Like when the police solve a murder, it's not profitable, but they do it because their job is to fight crime. And so the fact that they would stop doing this activity once it stopped being profitable just shows you that it was not a sincere effort to fight crime. I should point out there is still some work to be done. There is forfeiture at the federal level. And in addition to the federal agencies using forfeiture, what they will sometimes do, which is pretty disturbing, is they will pay local law enforcement to ignore state law and help them file a forfeiture in federal court where those protections don't exist. So we're still working on that. I'll be back in Tallahassee again next session trying to close that loophole. But we have made tremendous progress. And that's the one area where it's really been done legislatively instead of in court. My favorite thing to do is to sue the government, right? It's to go to court and get precedent. Like that's what gets me excited. But if I can create meaningful change in Tallahassee, then I'll wade, into the mud with those unprincipled legislators and sometimes, get reform in a way that helps out the society.
You love suing the guy. I love hearing that. And I think anybody listening, obviously everybody has their issues one way or the other with the government. Right. And I want to go back to something that you said when you were helping craft the 2016 Florida civil forfeiture reforms. You said you worked with people on the left You work with people on the right, Democrats, Republicans.
Right.
Some people, if they look up the Institute for Justice, they'll say, oh, it's a libertarian group, but it's not a libertarian group with a capital L, is it?
Right. No, see, we're philosophically libertarian. So we're what's called small L libertarians. Like we think government should be limited by the Constitution, and that should be done consistently. Unfortunately, in my view, I think sometimes people on the right and the left tend to focus on the parts of the Constitution they like and don't respect the other parts. We think we should respect the whole Constitution, but we're completely nonpartisan. We'll team up with our friends on the left. We'll team up with our friends on the right. We'll also sue Republicans and Democrats about the same number of times. And so for us, I mean, I love my job so much. And one reason is because I'm one of the few lawyers out there that has the rare luxury of being able to operate entirely out of principle. We're not political. We don't have political grudges. To quote the great Frederick Douglass, I will unite with anyone to do right and with nobody to do wrong. And that's our approach. And so, and we find that, the more diverse coalitions we can put together, the better chance we have for meaningful reform. And so that's really what our goal is.
Well, I mean, I just think it's remarkable, and I love reading about the articles where you're put in there. I saw that you were named one of the most effective litigators in South Florida, so I know that was quite an honor for you as well.
Thank you. I appreciate that, and I think that really just reflects the opportunity I have at IJ to do cool things. I mean, when you win cases in ways that have never been done before, that gets the attention of those types of organizations, but again, really, I think it just reflects the fact that I work at a place where most of our cases involve things where we're challenging things in a way where they've never been done before. And so I'm just very fortunate.
In fact, I believe I read somewhere you had 7 United States Supreme Court cases that are active right now?
Well, not active. So,
okay.
And again, just so we're clear, I'm not the one arguing those. I have filed briefs at the Supreme Court, but I'm not the one who stood up and argued.
Okay.
We've had 7 U.S. Supreme Court cases in our history. One is still pending. That's a case out of Tennessee involving residency requirements to open up alcohol store businesses. But of the 6 that have been ruled on by the U.S. Supreme Court, we've won 5. The most recent one was this term also. It was a case called Timms versus Indiana, which addressed that civil forfeiture issue I talked about before. That was a case where we represented Tyson Timms, who was a very low-level drug addict. Like most drug addicts, he sold, a few $100s worth of drugs to feed his addiction, at which point the police tried to take the brand new car he had received when his dad passed away, even though they knew it didn't come from any drug activity, but they really wanted that new $40,000 SUV for their police force. And so we represented Mr. Timms at the U.S. Supreme Court. And the issue there was whether the 8th Amendment's excessive fines clause was incorporated against the states. That question hadn't been resolved before, but thankfully we convinced, and by that I really mean my colleagues, convinced the U.S. Supreme Court that it was incorporated, that it does apply to state and local authorities. And now because we won that case, everyone throughout the country now has the benefit of using the 8th Amendment, even when it's the state or local government trying to take your stuff.
Well, Justin, this has been a fascinating conversation, and I really could go on forever with you, but I don't want to go on for the rest of the day. I know you have to get down to Miami, and I have some things that I need to do here. For those listening, law students, lawyers, or anybody who wants to learn more about the Institute for Justice, how can they get more information?
Well, I mean, obviously, if you Google us, you'll see a ton of stories because our cases are so cool that they get a bunch of media attention. But probably the best place to go would be our website. ij.org. When you go on there, you'll see just a wealth of information, including a case page for just about every case we've ever filed. So if you want to learn more about, the civil forfeiture cases or my skim milk case up at the 11th Circuit or the U.S. Supreme Court case that I just discussed, Timms versus Indiana, there'll be pages and pages about those cases on our website. So yeah, ij.org is probably the first place to go.
That's terrific. Well, thank you so much for being with us, Justin. And I always enjoy talking with you. It's always at a different level than I usually have on most legal issues and most any issues. And obviously, you're very well versed in your material, and you're a real asset to the organization. There's no question about that.
Thank you, Jeff. It's fun. I know we used to be friends back in my old life before I joined IJ, and it's nice to see you again and spend some time with you. And thanks for having me on.
Absolutely. Well, We have one last show for this first season of Questions for Lawyers on Friday, June 21st at 10 a.m. I will have Michael Minardi, who is leading the Regulate Florida movement. He is the chairman to legalize marijuana. And whatever side of the fence you're on with that, he's going to tell you what the state of the law is, how he's trying to change things, how things have changed over the past few years. And it should be a fascinating conclusion to this first season. But for those of you watching, listening, I appreciate it. Again, my name is Jeff Adelman. And I just want to remind everyone, quote by Robert Stevenson, compromise is the best and cheapest lawyer. Be well, everyone. See you on Friday.